So San Diego employment attorney Ward Heinrichs is right back here on Big Blend Radio again. He is joining us on our Success Express show to talk about more about what's going on in California in regards to new employment laws for 2019. Now, he's got a full article detailing all of that and also an interview. If you go to blendradioandtv.com, just type in California Employment Laws 2019 and you'll see it. But today he's joining us to get into the nitty-gritty of what's going on in regards to the new sexual harassment laws, the Me Too laws. Ward is a regular Big Blend Radio guest and contributor to Big Blend Radio and TV magazine. He's also part of Parks and Travel magazine because he talks about tourism and hospitality. Sexual harassment is part of that too, because half of the time people rent a hotel room, just saying. But anyway, you can learn more about what he does. He's based in San Diego. Go to his website, bestemploymentattorneysandiego.com. He's also got a blog on there, also talking about all the new laws. He's also on Twitter at Ward Heinrichs and Facebook as well. Hey, Ward, welcome back. How are you?
I'm doing well. How are you doing, Lisa and Nancy?
Well,
good.
We're doing good. We're doing good. We're all like excited. We're listening to good music on the show, talking about tourism, hospitality, but like sexual harassment. I suppose we shouldn't really be like happy to talk about that, right?
I'm the bummer today, I guess.
No, don't say that during sexual harassment. But anyway, no. Honestly, sexual harassment comes in so many forms, and it's interesting going through these laws, the ones that everyone, the award has an article up right now, blendradioandtv.com. It'll also be in the spring issue of Parks, Big Blend Radio and TV magazine. Got to keep all the magazines straightened up here. But this really gets into the nitty-gritty of it. Are all of these kind of the way it's been for a while, or is it really just a lot has changed with the Me Too movement?
Well, we certainly saw the California legislature push much more, use much more energy into trying to nip this off at the bud. And when I say nip this off at the bud, I'm really talking about all the stuff you've seen in the news. I mean, it's really cropped up in the last 2 years. And so they really spent time crafting legislation. And some of the statistics I read, that there were like another 200 more sexual harassment proposed legislations than there were the year before. So this is really part of the Me Too movement, and the California legislature has taken that on.
Wow. Okay. So, and this is what I was thinking too. When we think about sexual harassment, I know it's in every industry. I know we've talked about it over the years, but you're in California. And even San Diego, I mean, you've got, Frankie and Gracie, whatever, being filmed in La Jolla, right? You've got all of the arts, not all of them, but a lot of filming and music in L.A. and San Diego too. And that's what we see mostly on the news, is it has to do with actors and producers and, I mean, Kevin Spacey and how did what? Bill Cosby, R. Kelly. I mean, all these dudes are going down, and it seems to be that you are sitting in that hotbed. So do you think it's like California's taking on a bigger stance because of the entertainment industry?
I do. They did direct some of the new code sections at just that industry. They expanded the types of business relationships that can have sexual harassment allegations and cases filed within them. Before, of course, there's always employment, but there were other limited areas where there's a relationship, a business relationship other than employment, like an attorney, a doctor, professional relationships, where if there was sexual harassment there, then that was prohibited and could engender a lawsuit. They've expanded that to include directors, producers, and those who promote businesses and professional relationships. So promoters, they're big in Hollywood, and they're big in promoting their clients, who could be actors, actresses, etc. So, yes, they've really focused on that industry. Now, not exclusively, obviously, but that's one industry they have focused on.
Wow. But doesn't it come from somebody being in a position of power for example, somebody works for somebody else, the employer has the power and can call the employee, do this, do that, do this, do that. And then sometimes the employer may ask for something the employee doesn't, it's outside their job description and shouldn't be happening, but because they feel they may not keep their job unless they do what's requested. I mean, I just feel like, and it could be male or female, it's a position of power, of one-upmanship. I'm higher on the level because I'm paying you, so you must like dance to my tune, kind of thing.
Well, I think you're right, at least in many cases, and that's why the original harassment laws, back in the 1980s, and before then too, the federal one was before that, were first created because there is a power relationship in employment. The employer has more power than the employees. They want a job, he or she can say, no, you can't have the job, or no, you got to do this to keep the job. And the law backs that up. But because there were these abuses, harassment abuses, discrimination abuses, the legislature said we got to address this inequity of power and prevent misuse of that power, at least in this way. And I think you also see it not just in positions of power, but also in positions of trust. And the law I was just talking about before, which is under Civil Code 51.9, really lists maybe not positions of necessarily power, but trust, like a doctor, maybe more power, but it's more of a trust relationship that could be abused. And, same thing I think with directors and producers, although, the producers, the big suits we've seen about that does appear to be a power thing more than just a position of trust. But, it also talks about investors and lobbyists, and so that's more, I think, a position of trust. So I think it's both, but certainly position of power is one thing where the unequal power has led to this type of abuse.
Well, in your articles over the years, you always put the codes, right? Those little squirrely things, and it's like 51.9. Well, that's how but I'm thinking about, people that, now need to look up stuff and, have never had to look at employment law, but they're in a predicament. And so it's important that you give that because that's how they can look up things, right, online.
I do try to do it for that reason. And the squirrely thing is actually section, so Civil Code Section 51.9. Yeah, so hopefully people can look it up. Sometimes I'll cite the original legislation, which is either in California Assembly bill or a Senate bill, and that doesn't. The language in there gets taken from the bill and put into the code section. So it's hard, sometimes it's hard to find the Assembly bill, and it may have been changed, and so the code section is easier to find and it's more accurate.
And this, I want to go to this because you were talking about, Civil Code 51.9. I just want to get one of those little walkie-talkies like a cop and go 51.9 to the left. But anyway, the harassment prohibited in more non-employment business relationships. Now, when you look at this, and I look at our conversations over 2018, and we talked about the difference between independent contractors and employees and how this is getting all changed up. And as soon as I read this, I thought, oh, my gosh, here we go. This lawsuit, to me, could actually start to get into that weird side, not like a lawsuit, but that code, that whole thing where it's not an employment, law-related thing, yet at some point it could be because it's still someone's business. If you're an entertainer and you're working with a producer, eventually those lines could get blurred and changed because of that independent contractor thing. Did that make sense at all? I know you know what I mean.
Well, I think. Let me see if I do understand. Most times when we've talked about harassment and discrimination, we've talked about in the context of employment, the employer against the employee. And we've branched out and we said, well, the employer also has a duty to keep the workplace safe. And and if there is an outside person who comes in and the employer knows that they're harassing one of his employees, the employer could be liable. But the code also says that independent contractors can be harassed and bring claims for it. So, and maybe we didn't really touch on that too much, but that has been the law for a while. So, independent if this is what you're talking about, independent contractors can be victims of harassment, but can file a case under the old government code sections 12940, which is the FEHA law, Fair Employment and Housing Act.
Okay, because
so that's been there for a while.
When we talked about the musicians playing in a club every month or something like that, and it's being advertised, so then they're not necessarily independent contractors, but could now become employees. That's where I was going with.
Well,
this.
Okay.
See what I mean by 51.9?
That's okay.
If you have a residency at Pachanga Casino, Temecula. And I shouldn't put names out like that at all. So I take that back, Pachanga. You guys are awesome. And
plug your ears, everyone.
Yeah, but you know what I mean. I didn't want to say Vegas because you're in California, but you know what I mean. If you had a residency, and so many musicians do, they'll go in for a month or a year and have a residency, and then that weird law that you talk about all the time. Mm-hmm. And maybe you came in from New York and ended up with a residency for 6 months. Now that gets weird, and sexual harassment occurs. So maybe that code 51.9, Roger, would come into play at some point with that.
It could. I don't. Well, maybe a musician would be included in that, possibly, but probably not. I think it goes to more of a profession, licensed professionals, and then some of the other ones I just had talked about, promoter, director, producer, lobbyist, etc. So I don't think 51.9 would fit the description, the situation that you're talking about. But you did bring up a really interesting issue, and it's a little maybe off topic, because what we were talking about back when we talked about the musicians potentially being employees was in relationship to the wage orders and violations of wage and hour regulations in the wage orders. And the California Supreme Court came out and said there are many more. I mean, I'm really summarizing. It's dynamics, the dynamics case. There are going to be many more employees than there were before, and a lot of the people you've been calling independent contractors are now going to be employees. And we talked about in the context of getting paid properly as an employee. But that is one definition of employee, and there's a different definition of employee in a lot of these code sections. And there was a recent case that really spelled that out clearly. It said, hey, look, the Supreme Court in Dynamics was very clear on it. It said you got to look at the code section first to see whether the definition of employee we're using here could apply there. And in many cases, it's not going to. It's its own definition. Yeah, so determining who is an employee for what can be a little like a maze. It's not always clear, and you really have to track down the language of the code.
I know.
I hope that's what you're getting at, because
that's what as soon as I saw this, I went, oh my gosh, this is gonna get, and I swear in about a year to 2 years we're going to be revisiting this over the independent contractor thing with this. It's going to all merge in some weird thing. I don't know. I'm just saying, we'll have to call Hot Mama Babushka for that.
No, but if
she can tell that.
If someone look into the future and tell us what's going to happen. Getting back to that real fast, it's really going to be each code section can very well have its own definition of employer, employee. And so I think what's really going to happen is we're going to be all over the place in terms of what the definition of employment and employee and employer are for each different code section. Now, the default's going to be the old default that we've used for years and years and years, and it's the 9-10 factor test that you just apply that to the facts of the case. But it's very complicated. It's not easy. It can go either way, except for in the situation where you've got a clear reference to the wage orders, and that's going to be the simpler ABC test. So, we're going to have to, I wish
That's a whole nother
Madam
show.
Babushka could help us, but it's going to be a while till we figure all this stuff out.
So if a homeowner employs an independent contractor to paint the house, and either male or female being the person paying the independent contractor to paint the house, but every time the people come in to paint the house, somehow
can it be a pool boy?
The person, yes, harasses the painters or paintee, as it were, they make advances towards the people painting the house.
Okay.
Yeah. How does that work now? Can the independent contractor file a suit against the person, but they're not really an employee, but they're coming back time and time again? Because I think if somebody comes in once, does a job, and leaves, and nothing happens, there's nothing going to happen. But when you have repeated contact,
well, if it's a cute pool boy,
if it's repeated contact, then the chances of harassment is way larger than, or more, likely to happen than one time. So,
well, under the FEHA, the Fair Employment and Housing Act, the independent contractors are protected from harassment. And so if, I think you're talking about an outside person comes in and harasses them, and if the person in control, now it's not an employer, but, the contractor, the contractee maybe, is there and is on notice of that, then they could potentially be liable in that situation for the harassment. Now, and honestly, I haven't seen a case like that, and I don't think that because normally it's an employer with an independent contractor who's coming in, and the independent contractor is being picked on by the employer. Could it be possible that a third party could come in there on notice? I think so. I can't say that I've seen a case like that, but I think logically it can happen. But I think that logically happened under the old law, and I don't think the new laws. I mean, again, I've listed some of the laws, not even all of them. I think the major ones that have tried to address this Me Too movement and the harassment that's going on, and these don't really address most of these don't really address that specific situation, because there's things about confidentiality clauses, and if there's sexual harassment, then the agreements can't have certain waivers in them and things like that. So most of it is fine-tuning different areas where you might have a case and might be addressing some of the issues in the case. Some of them do expand, and we've touched on a couple of those. So, but in general, overall, there's an expansion of everything to protect people who have been harassed. And it's really sexual harassment. It's really Me Too. It's
yeah. I'm glad we're talking about. I know it's we're not really off topic, but we are. But the reality is, I think sexual harassment, we don't know where it sounds crazy. We don't know where the lines draw. When something happens to you, and as someone who's a victim, you may not know, is this employment law, is this or that? You know what I mean? So I think it's important that all of us understand where, okay, this is where you go for that. This is where you go for this.
Well, what's acceptable? What isn't?
Right.
Yeah, and what's acceptable and what's
like
not. And
flirting in the workplace.
Yeah, I mean, there's a line. And so I think that's, if watch The Office, half of that, you're in trouble, So
right.
You're in I mean, if you watch any TV show, half of it, there's like, Nancy and I watched that. Boom. Ward, look at that. Is that and you'd go, that's TV and it's wrong. Yeah, I know that you tell us that everything we see is wrong. wrong. But
it happens in offices.
But I want to touch on something important. I know we touched on this when we were talking in December about the 2019 new laws, California employment laws, but I think this is so important. The first thing you bring up in your article is sexual harassment training, because this is something that everybody really needs to get on board with right now, right? And not
absolutely.
mess around with this. So, and it's changed. So from last year, this has changed, and you need to start now if you haven't.
Yeah, I've been talking to most of my employer clients about this. When I go to referral groups, I talk about this because before the law had changed and it became effective on January 1st of this year, only employers who employed 50 or more employees had to give training to their supervisors. Now, employers who have 5 or more employees must give training to their supervisors and to everyone else. So it's 2 hours for supervisors, and it's 1 hour for all other employees. And they're really, I mean, other than the limit of 5, if you have 4 people, 4 employees, then you don't have to worry about it. But other than that, there is really no exception. You've got to do it. And any past training that has happened will not apply to this new law. So you've got to retrain. If you trained in November of last year, your supervisors, you got to retrain them this year.
What if you're a seasonal employee? Like I know, spring break in some areas, summertime's coming up in San Diego, and so a lot of resorts and places like that will start hiring extra help. Is that important for that if you're not a full-time employee?
Yes. That's good. Another good point that you brought up. It applies to part-time employees as well. And temporary employees, because maybe a temporary employee is a full-time employee, but only for a short period of time. So, if you have a temporary employee who works fewer than 100 hours or fewer than 30 days, then you don't have to do this training. But if they work at least 30 days or 100 hours, now you have to train them.
Okay.
Wow.
It's really changed up, and so everybody, the squirrely section codes are 12950 and 12950.1. Roger that. Well, no, I know.
Sounds so official.
I know. I remember the first article you sent, and I looked at that. I was like, "What are we doing German with those little bee things?" And I'm like, "What's that?" And then I had to look it up. I had to learn, and I was like, "Okay, Ward, all right, you're the attorney," and I started learning right from there, and that's true. I think for people to know.
So, Ward, do you have any idea of how California law sits to the rest of the country? Like, is California law streaking ahead or behind, or what do you have any indication countrywide how these kinds of laws are falling into place?
Well, traditionally, California has led the country in this type of legislation, and certainly it's ahead of the federal laws.
Oh.
I can't really tell you for sure what Nevada has done about it this year. I don't practice Nevada law, but sometimes I get a feel for the trends, and I just don't have a feel for the trends in other states. Although I have heard New York has passed some pretty tough laws on this too.
I think it's always California, New York, and Washington.
Yeah.
Nevada is weird. It's kind of like Arizona's changing up a lot on things.
Nevada's got Vegas, and we don't want no laws there.
Yeah, well, you could have prostitutes, but you couldn't smoke weed, and I'm like, what? I mean, don't they go hand in hand? I'm just saying.
Well, hello.
And now both are legal, so now it's total happy land, adult Disneyland, but they're trying to get more into the family mark, and I'm like, yeah, well, that's a whole other conversation.
No, wait. How would you handle? Now this is funny. In Nevada, how would you handle sexual harassment with prostitutes?
Yeah, right. Sorry.
Well, if you have an employment relationship with them, then certainly under the federal law, there could be harassment.
I know people trying to raise campaigns on prostitution that it should be legal so that they can get help and have medical care and things like that, because it helps both parties, those receiving, those giving, and all of that, and protection, if somebody is abusive and things like that. So there's a movement on that too, and that could end up in employment law. So Lord, you never know.
No, it sure could. I mean, if it were legal in California, it certainly could. Now,
there could be like a prostitute union.
I know. But anyway, let's go back. I want to go back. I want to get us back on track here.
Okay.
No, because what's interesting about these laws, it really did come from defamation and then also confidentiality, and these are two laws. So let's start with Civil Code 47, harassment, defamation, protection. This is something that's really changed up too. So tell us about this, because it's kind of like, once you've done it, you can't tell on somebody, or it's kind of like you can't use it against them, or can you? I need help.
Well, the law's changed. Civil Code Section 47 is the defamation statute in California. So what was a common defense, and certainly sometimes has a good basis, would be to if you're being accused of harassment, filing a countersuit and saying, or maybe just filing a suit as an initial salvo of litigation about being defamed, lied about.
Mm-hmm.
And if you can prove that, then you can prove damages,
okay.
and you might win some stuff. But what the legislature was afraid of is that too often that is used as a defensive mechanism without a good basis. And so they wanted to limit the use of it in at least certain cases. So what they said was, that these statements made to employers by harassed employees are privileged and can't be used in litigation if those statements were made without malice and with credible evidence. And so that's a very interesting standard to measure privilege by. Normally it wouldn't be measured by that standard, but so here's what I'm envisioning. The defendant files a case for defamation, and then they say, we want all the statements of the accuser so I can prove my case.
Oh,
then
wow.
the accuser says, hey, those statements I made to my employer, they're privileged. You can't have them.
Wow.
And then then I would imagine that the accused, the one who is now filing this defamation lawsuit, would say, well, wait, those were made with malice, and there's no credible evidence to support it. So then you'd have to fight about whether they were made with malice and credible evidence, and that's going to be a tough call, I think, for judges to make about evidence. But I understand where the legislature is going with this, and it's just a way of protecting those who feel harassed, as long as they can show, hey, and I'm not sure who would have the burden of proof. Maybe I think it makes sense to put it on the harasser. I mean, on the one who is accusing, that they would have to prove, I didn't do this with malice, and the evidence is credible.
Well, that's what happened with Bill Cosby so much, with what he went through. Not that he went through anything, he did it, whatever. I'm not going to get into that. But if you look at, look at, Bill Cosby, that dragged on and on and on. And it was like that whole thing of, are you doing it to get back on? Are you getting on the bandwagon of taking someone down? Because there is that part of where people start coming out and accusing people. Who knows what's going to happen with Kevin Spacey? But there's a bunch of people that will jump on that train, and it really sucks for real victims when people do that. So they need to be taken care of with doing that. Because it's wrong,
Trying
wrong.
To find out.
Well, right, and that's the other side of that coin. Is it can be misused. The person who's saying I've been harassed can misuse that.
Yeah.
And so I think the legislature is trying to strike a balance here between the two. And I think maybe even the more important one, maybe not more important, but very important, is the one where the employer can tell a potential future employer of an applicant who used to work for the employer that they would not rehire that person because we found that they had sexually harassed someone.
Oh, wow.
So that is now protected and privileged as long as it's not made with malice.
Okay, I know this may not have to do with.
Wait.
Okay,
wait.
okay, go, Nancy.
No, okay, wait. Go back again on that
Yeah,
one.
because
so somebody used to work for a person, and somebody
he or she may have something in their past, right? That they have.
Someone used to work for a
employee.
person and they were accused of sexual harassment. The employer investigated and decided that they had committed sexual harassment, and whether they terminated them or they left or whatever, now they're no longer working for that employer.
Right.
But they've applied for a new job, and the new potential new employer is calling them up and saying, "Hey, would you rehire this person?" Which is a legal question to ask, and it's legal to say no. It's been the law in California for a while.
Okay.
But now they've gone out of their way and said, "Hey, we're going to make sure that any employer who says no can also say no because we think that he or she committed sexual harassment."
Okay.
And that means
Wow.
what happens then? Maybe the applicant doesn't get a job and goes, "Hey, my employer must have said that I committed sexual harassment. I'm going to sue them for defamation." Sue my old employer for defamation because they told them.
Okay.
Wow.
But then,
And then, they do that, and then the employer says, "Hey, wait, I didn't do this with malice, so you can't use the statement in your case against me."
Wow.
Yeah,
I'm
it's
so
really
glad
technical.
You're the attorney.
Okay, but
It's technical evidence stuff, but it really is important.
with the phrase "with malice," I am imparting information as opposed to "I hate you and I'm going to say this."
Yeah.
That's my definition.
Yeah, I'm going to kill you and eat your feet comment. Yeah. Have you seen the movie Malice?
No, but I'm just saying.
Yeah.
You know, with malice, like you do it to hurt the person.
Yeah, you're after them.
Or here's just a matter of
Right.
record.
Yeah, okay.
Wow, how does the court discern that? Wow.
Well, that's why I said it really isn't a very easy test, I think.
Yeah.
Because how do you prove malice? Well, one way would be, well, did they lie? And, if you get a bishop to come in and say, "Yeah, I know they lied about it," is that malice? Yeah, maybe.
It's about how people know how to hide their true things. If you know how to lie, you can get through it.
I think you have to look for the ulterior motive.
Oh, see, we're women. You know how we are. Like, we know how to manipulate, Ward, you send us on the mission of Law and Order stories.
Oh, it's going to be so
on
much
our
fun.
Love Your Parks tour. And we did our first one in our Parks and Travel magazine on Pearl Hart. And she was the first gun-wielding, pistol-wielding lady who stopped a stagecoach. She got put in the U.S. territorial prison, and you know how she got away with it? She was all la 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 to the guardsmen and everything. She was one of the first women in there,
and
she pretended to be pregnant. And she got out.
And
she went in and out like you wouldn't believe, and they all escaped in and out all the time. But that's how she got away with it, man. And then she married some dude, and anyway, she.
Great story.
I know, but that's what I'm saying. It goes back to this, where okay, are you doing with malice?
That with malice?
Yeah. Well, she became she tried to become an actress, Pearl Hart, because she knew how to manipulate. She tried to become an actress. She had a media sensation about her because of what she was doing in the prison. She created all kinds of chaos, wanted to become an actress, and then, so the whole malice thing, how are you going to know if someone's real or not?
Well, most of it's going to be circumstantial unless they say, "I am maliciously saying this statement," and then they say the statement, in which, how often is that going to happen? It's not.
Yeah.
So it's going to be the circumstances. It's going to be the evidence around it. The future employer or the potential future employer could say, "Well, when they were saying that, I really thought that they were angry at this guy, and it didn't sound believable to me. So, we hired the guy anyway, and he's a great guy, and I think that they wronged him." Now what's the damage? Well, that's a different question, but because he did get the job. But
he's friends with the owner.
That could be too. So that would be a type of evidence that might show malice. There could be all sorts of other things that might show malice. A letter and how it's written. But you're right. It's going to be mostly circumstantial, and you're just going to have to weigh that with the statement that was made and come up with a decision.
This is why we have courts and attorneys, because it gets complicated.
Okay, I know when people hire people, right, they're not allowed to say, like, were you in prison, right? You can't put that on the application, like, were you in prison and stuff like that? Are you legal?
Oh, ban the box laws?
Yeah, right? But now, if you know where the applicant is or your person lives, you can find out online whether or not they're a sexual offender. So someone with malice could go in and go, I know where he lives, and he's a sexual offender, and that's that. But the employer can't. But the employee could. See? Crazy.
Yeah. Lisa, I'm not going to really touch that one.
Okay, no, but I'm just saying, like, people will know, like, people can tell when someone's a sexual offender, and if they've been hired, I'm saying people can get hired into a company. I don't know. I want to know about what happens with sexual offenders. Can people hire them without knowing? I mean, really? That's
No. I mean, the ban the box. If we're talking about ban the box is a way of restricting knowledge about criminal history until a provisional job offer has been made. So rather than screening early for that type of thing, you have to now screen later and then justify it if that's the reason. That if you go, well, after I gave the provisional job offer, I looked up the background and found that they had committed many felonies in Nevada, and so then I said, and these are serious, they're all theft, and I don't want them to steal from me, so shoot, I didn't hire them. So that's pretty good justification at that point. What they're trying to do is get more people who have been to prison or have some type of record employed versus just being knocked out of the box before they even have a chance. That's the idea behind it.
Well,
I get that.
When you go to prison and you serve your time, that was supposed to pay your debt to society.
You're done. Yeah. I mean,
well, I was having this conversation just yesterday at a referral group, and they were talking about this situation where if you find felonies, do you want to hire someone? I'm saying, well, ban the box says this, and they go, yeah, but boy, do I want to take a chance? As I looked it up, and it wasn't very good, and so just because you've done your time doesn't mean there isn't still prejudice. And, is it wrong or is it right? I'm not even going to go there.
No,
it's just the law right now.
Because that gets political too about, can you vote or not?
Whoa.
I know, but this is I mean, when you bring in all these different laws and everything that's going on really right now, it's deep, man, and there's so many different ways and things happening. But so we've now done the defamation protection, right? Now let's talk about confidentiality, because this clause, the settlement confidentiality clause, I think is one of the things that really spurred the Me Too movement forward, was this clause.
You're right.
It is. And so I got something right today. Good. Okay. And everybody.
A+, Lisa.
Section 1001. There it is. I'll say it correctly. No squirrelies, but it is a squirrely. But explain this, because this really goes in depth about, this agreement.
Yeah, and just to be clear, this is the Code of Civil Procedure, which is not the same as the Civil Code.
Okay.
Anyway. So if let's say you have a case of either sexual assault, sexual harassment, some type of harassment or discrimination, and it doesn't necessarily need to be employment-based. It can be in other situations. Retaliation for reporting harassment or discrimination. If any of those things happen, and or at least alleged to have happened, and there's a settlement because of the allegation, then the settlement agreement can't contain a provision that would prevent that person, the person who's claiming it happened, from disclosing the facts of those situations, of the harassment, the assault, the retaliation. So now, and you're right, because there, we saw with I think with Stormy Daniels
Mhm.
and our president, there was this clause that made it difficult for her to say what was going on. Now, whether you believe it or not, I mean, who knows? But whatever.
Yeah.
Yeah.
There was an impediment to her even discussing it and talking about it, and that's what this new code section is going to. It's saying, hey, if it's a sexual assault, sexual harassment, retaliation because of it, then you cannot prevent someone from disclosing those facts through a settlement agreement.
Even if they signed a thing and took money for it to shut up.
That's what.
Because that's what happened with that reporter.
Okay,
I mean, it was like.
So it's interesting because is this retroactive?
Excuse me.
I know. Can it go backwards, like in time, and like let all these women have their
No, I'm
settlements?
just wondering. When they put a new like statute and law in place, is it retroactive?
That can be a very interesting question. Sometimes the Supreme Court says yes, sometimes no. In something like this, generally not, and I don't think they'll say that it is retroactive, and I don't even know if that's an issue that would be brought up about this. Certainly from this point forward, you can't do it.
Wow. This is interesting.
So the non-disclosure agreements that are tagged onto almost everything that you ever signed these days, would that come into play? This where you're not supposed to say anything about what you just
But that's
said.
the point. Yeah, that's the whole thing, right?
I know, but I mean, this is still on almost every form you sign.
So basically, whatever you sign, you can just undo when something has really gone down.
If it's one of these sections, issues that we're talking about, the sexual assault, sexual harassment, discrimination based on sex, retaliation based on those things, yes, then you're allowed to disclose the facts. But settlement agreements can still have the provisions that prevent you from disclosing facts for other reasons.
Okay.
So,
trade
if it's wrongful discharge and it's not sexual related, then they can say, you can't disclose the facts of this.
Wow. This is interesting, man. This is really changing up a little bit. And I think, what about the accused? Like R. Kelly. Hey, Ward, I think you need a Craven Raven cocktail.
I do.
It
but
sounds like you're getting
I'm having a dry
cold.
January, so I don't. I haven't been drinking all January.
Oh, see, that's what's happened. See, that's what happened.
It's making me sick.
That's a non-disclosure.
And we're not even doing a happy hour show. That's so wrong. That's the problem. Yeah, but anyway, we'll send you some, cocktails over right now, but they'll, we'll take all the good stuff out and save it for Priscilla, our little sock monkey here. But going back to this confidential clause, it's really for someone going against the person who allegedly did something, right? What about the person that didn't do it but is being accused? Do they have any leg to stand on things at all? Because, I mean, some people are getting accused and then you don't, I don't know. It's hard. When we watch in the media, you don't know. You just, you have your emotional thing or your reactional thing, but you don't know. And what about the person that just, that goes back to the malice thing, right?
Yeah, it does.
Okay.
The defamation issues that we talked about before, and whether the statements are made with malice, and if they are made with malice, then they're not protected anymore, they're not privileged. Mm-hmm. Yes, and that's trying to strike a balance where the accused has the right to file a defamation lawsuit saying, hey, you lied about this. So that right is still there, but more of the information that used to be used will now be privileged.
So this is,
but they have to prove it.
But then
they can't just say you lied about me. They have to prove it.
So these two
clauses
could go against each other, right? Like they could butt heads in court, like at some point.
Well, yeah, like we were talking about, the accused, is going to say, I want these statements, and maybe they heard them, maybe someone else heard them, somehow they found out about them, or they just think they were made. They may say, what did the employer, when you brought this up to your employer, what did you say? What did the employer say? And that used to be fair game. And now they're saying, well, wait a second, that is now privileged, so you can't get to it unless you prove it's with, with malice and it's credible. It's probably, I think the burden's going to be on the accuser to prove that it's without malice and is credible. But so the person who's filed the lawsuit, the accused, is going to run into more problems getting the evidence they want to prove that there was a lie told than they did before.
Wow. Okay, so I want to move forward here because there's still more here. Civil Code 167.11, a waiver of right to testify. Okay, wow. Okay, so explain this one because
I mean, there's case law that talks about this situation, and that if a legislative body, or normally it's an administrative agency, wants to investigate something, there used to be statements in some settlement agreements that said you can't disclose any of this information to anyone, anytime, anyhow. And then there's case law that said, well, to the EEOC you certainly can, and to the SEC you certainly can, and that's broadened over time through cases. Now, what this puts into a statute passed by the legislature that says, well, if there's criminal conduct or sexual harassment, and a court, a legislative body, or an administrative agency wants you, who have signed a settlement agreement, to testify about these things after you've been subpoenaed, court-ordered, or had a lawful request, then you are allowed to, and the clause that may, in your settlement agreement, that may restrict you from doing that is now void. So you can go ahead and testify. And like I said, a lot of the law was that way anyway through case law, but this makes clear that in situations of sexual harassment and also criminal conduct, that now is certainly, there's no way around this.
Oh, wow, that's cool.
So you can testify and your employer can't come after you or do anything bad to you later, like fire you.
What usually happened, what usually happened, and that's, may have been, settlement agreement, normally after a settlement agreement of this type, you're not working there anymore, usually. So maybe it's not a firing situation. But what's happening is maybe there's another person who has the same claims and wants you to testify about the Me Too evidence. This happened to me too. This happened here. And then you weren't allowed to because of this provision. Now, like I said, there's a lot of case law that would allow things like that, but in every situation it could be different. But here now, clearly, if it's about sexual harassment and a court wants to hear it, you're allowed to testify no matter what your settlement agreement said.
Wow. But that I think is an important thing, especially in an office situation, because I know Nancy and I have both been on that side where the women all know what's going on with some
different dudes.
Thank you. And you all know, you've all gone through it or whatever, and you all have each other's back, and you know what's going on, and you can't testify at that point. And it's like, and you're scared to because of your job. Everybody is scared about their job, And I think at the end of the day, when you look at employment law, to me, all these injustices always end up being like, I don't want to lose my job, or people will walk out of their job if it gets bad, and they may be one of the best employees the company has. And because, stupid stuff is happening, you could lose one of your best people that, you never know, that could catapult you into, being the next PayPal or something like that,
The dialogue has changed. I mean, what was considered maybe 30, 40 years ago as flirting has now become, that's not flirting, that crossed the line. And the definition of what is, I don't know if you can say innocent flirting on the part of male or female, is when do you cross the line with the things that you say? And I'm going to go back to the position of power. You can say something that is not respectful if you're on the same level in a company, but as soon as somebody is higher up than you on the chain and says something, now you have a problem.
Mhm. Yeah.
Well, and California law recognizes that situation. Harassment is a boss who harasses a subordinate is strictly liable under California law for the harassment. The person is on the same level. Let's assume it's a man and a woman, and the man is harassing, and they're both managers at the same level. That is only actionable if the company by the company against the company, I should say. If the company is on notice. Now, harassment can also be against individuals, so the harassee could still personally sue the harasser, even if they're on the same level. But the company may not be liable because they may not know about it.
Right.
Wow. Okay, so I want to move on to gender representation, just on time here. Okay. On the board of directors, this is a corporations code, not a civil code, not a code of civil procedure, but a corporations code, and that would be two of them, 301.3, 2115.5. This is fun, Ward. I want to do this more.
I'm glad you're having such a great time.
I want a walkie-talkie for it. But this is interesting because we're looking at gender representation and women getting involved and being able to have a place, right? This is actually gets pretty in-depth as we go through, of women being able to have a seat on the board and things like that, right? That it has to happen.
Yeah, there's some very interesting little nuances in this law, but essentially by December 31st of 2019, so that's the end of this year, there has to, on publicly traded companies that are traded on a major U.S. stock exchange, there has to be at least one female member on the board of directors. And depending on how large the board of directors is, by December 31, 2021, there may need to be as many as 3.
Oh, wow. See? What if they're not qualified?
Yeah. You just stick them on there?
Well,
token? Your token women?
I
mean, we're women, and we want
don't you get those things in the mail and they go vote for? Don't you get those things in the mail? And they go vote for directors here, and I go, I don't know anything about these guys. I mean, come on. Do I know that they're competent? No, I have no idea.
That's
and I'm
not.
Lot,
but yeah.
I don't know about that stuff.
It opens the door, and I you know what the reality is, and I've gone round and round with this with friends and stuff about women in leadership, and the reality is women have been around in these places doing stuff that just haven't been recognized, and that's why I think these laws are there, and they are competent. I don't think they would be. I mean, there's just women that are competent all over the country doing good things. So I think they're there. I just had to throw that out about being,
No, but we want
competent ones. They're there.
The wording, you have to now have a woman, which sounds like the token, as opposed to, how can I say, you have to have a woman as opposed to recognizing different talents and different people and not taking the stance that we're only having men. For example, I could see maybe 50, 80, 100 years from now, things might go Amazon culture and go, oh, now we have to have a man.
Yeah.
Because it could flip the other way where everything's
and
now
women are good at that.
Women dominated.
We're good at that.
Like the Amazon society, it could go the other way.
Watch out, California.
Now, so shouldn't it just be that you have to have a fair sampling of all? I'm not going to go both. I'm going to say all
genders.
Well, so you're saying the law should say fair sampling rather than give a number?
Yeah, like, well, you
But
can't.
that's where
But
you
you're
get
still,
loopholes.
you're still requiring
The law
the
should
company to.
say the law should be more along the lines of you can't turn a person down because of their gender, as opposed to a number. Of you have to have this.
Well, that would be a little different, I guess. That's kind of an interesting approach, if I'm getting you right. You're saying maybe the law should say if females apply, or males or whatever, then you can't just turn them down because they're a female or a male.
Right. That's what
okay. Well, maybe that's a better way of doing it. I don't know.
He doesn't make the laws. He's just letting everybody know.
I know.
And
I mean, but it could be.
Yeah.
I mean, I could hear arguments about that, and maybe that makes more sense. I think there's many people who would say, no, we really need to, correct past wrongs. So in order to do that, we have to be more specific about how to do that, and which would be including the number of women on boards of directors.
And the reality is
so,
there's a lot
there's
of women
two
in
arguments
there.
to it, I suppose.
There's a lot of women in there that are competent. I mean, I don't know, just from all conversations I've had, it's like they're there. They're already doing it. They're not even getting paid, but now that's changing a little bit too. Real quick on that one thing before we go to talking about what the Secretary of State must do. When we talk about female, this is the other part that I think is really important. Female includes anyone who self-identifies as a woman. That is a huge piece of that bill. That's a big difference.
Very interesting. There are two things that caught my eye about this. There's a bunch of things that caught my eye, but the two things that I really want to talk about right now are that it could be a man who, genetically is a man who says, no, I'm a female, and so is that really accomplishing what you want to accomplish? Well, according to the law, that qualifies. And then if you have 6 or more board members, then you have to have 3 females. So maybe you go, well, we have 6 now. Why don't we just get 20 and have 3 females? And so then you dilute the numbers more. So there are, if you want to continue to be...
Wow, you and Nancy are on the same team.
Exactly.
Well, I'm just saying, if you really want to say, I don't really like this quota stuff, so I'm just not going to cooperate with it. I'm going to figure out ways not to. That would be one way to do it. I don't know. My sense is that there aren't a lot of people, businesses out there that will try to do that kind of thing. But it's possible.
But eventually that will get shut down. But in the meantime, there are
probably.
There are things. Okay, so we did an interview with Christine David Hallquist and Derek Hallquist. Derek is the son. It's the documentary Denial. They documented this. Now, Christine ran for office. Christine was Vermont Energy CEO and the first transgender candidate for governor, Democratic side in Vermont. We interviewed them both in December about this and watched the documentary. And it was really about what's going on in energy and, how solar works. And it really was a great thing of how you can't just go push a button and think everything's going to work on solar, and it's about balance. Just kind of like this conversation we're having today about sexual harassment, and this law balances out that one, and some don't and some do. Same thing, but it was also as he ran, David at that time, and was a CEO, and he's just a genius man, was also going into a change, a transformation into Christine and how the family dynamics, and as she was running, and it's like an amazing story. And so I think, I say that's that place where people need to be able to have that space to say, I am a woman at this point. I'm transitioning into that, or, going the other way. I'm transitioning from a woman to a man, and then your votes are going to change on that, on the number of women on the board. So there you go. You could say, I'm a man now.
So you have 3 women on the board, and one becomes a man, and so now you only have 2, and you're not in compliance.
But
wow.
I'm just saying that is this movement. So I think there's going to be, that part right there and that code is going to change. More is going to come from that, don't you think? Through this year and next? that more is going to expand on that.
Oh, I think you're right. Because we brought up a few of the problems. Another potential problem would be if the company changes its executive office, so they could move it out of California into somewhere else, and then they don't have to do it anymore. I think. Now it's got to be. I think that has to be noted by the Secretary of State on a report, but still you can. So I think if your fears are correct, and there are companies that are going to play games with this law, and there's certainly room to do that, then I think you're going to see things change. I think you're right.
Okay, we got like 1 minute left here. By July 1st, 2019, the Secretary of State must publish the companies that have at least one woman on their boards of directors. So this has to be now public. Like, everybody needs to know.
Yes.
What's going
on.
Yeah,
that's right. It gets published. That's right. The Secretary of State publishes it.
Wow, and there's like $100,000 fine for things too. There's like fines.
Well, the fine won't go into place until December 31st. Depending on the number of people you have, and there's reporting fines too. So if they don't report properly the number of people, women on the board at the time a report is required, then there could be a $100,000 fine. And then there's also $100,000 and potentially $300,000 fines if you don't have the right mix of gender on your board.
Wow.
So
Ward, I have a list of questions for you for like we have a lot of segments to do because off of this. Really, when I think about this, it's gonna be an interesting year, don't you think? In employment law, you gotta.
You know what?
You have a transgender person on your board, and nobody knows what to.
Yeah.
Which side does that count on?
Yeah. You have to go by what?
Well, no, if you self-identify. So if the transgender person says, I identify as a woman, even though there is genitalia of a man, you're a female, according to this law.
It. So what if you identify as a transgender and you leave it at that?
Oh, just generic transgender? You don't know which way? Well, I guess that's a problem.
Well, I think it's going to find out. But that's what I said about 2019 being an interesting year for employment law.
Well, Lisa, we've been doing this for, 5-6 years now? I think every year is an interesting year in employment law. There's always some amazing changes every year that I love to talk about.
I know. I mean, last couple of years it was minimum wage. Now it's sexual harassment and the Me Too movement. And looking forward to our next time with you, Ward. Everybody, again, Ward's article, more in depth as well, is up on blendradioandtv.com. Just type in sexual harassment, and you'll find Ward. That sounds terrible. I didn't mean it that way, but law with that.
I'm going to file a defamation lawsuit.
Just type in Ward, and you'll see all his articles up there and interviews as well. And the best thing, though, is to go to his website, bestemploymentattorneysandiego.com. He has got a great blog up there. Also has all the new laws for 2019 in California, the employment laws. And also just keep up with him there. Sign up for his newsletter. He's on Twitter. He's on Facebook. And, of course, always on Big Blend Radio. And, Ward, we have a special song today. You've been on the show with Nikki Chris.
Oh, hey, Lisa, can I get something in real quick? I'm changing my website up. So you're seeing the old website if you go there now. Hopefully in 2 weeks we're going to have a whole new looking website.
Oh, cool. Well, spanky, spiffy, cool.
Awesome.
We can't wait. We can't wait to see it. I've seen some changes going on around the place, Hey, Ward's also on LinkedIn and Alignment. Alignment. I call it Alignment, Alignable. Sorry. But anyway, all those networking sites. But we're going to play Rise. Nikki Chris, you've been on shows with her, singer-songwriter on our party shows. Her brand new album, Heartbeat, comes out February 5th. This is one of the singles she released prior to the album. It's on her album, Heartbeat. Everyone, NikkiChris.com, and it's NICKIKRIS.com. Rise was written because of the Me Too movement. And so we thought we'd better play this today.
Very
Absolutely.
Cool. All right.
So here it is, everyone. Rise, thank you all for joining us here on Big Blend Radio. We'll see you on Friday. We've got a whole bunch of more good stuff happening as well. So here it is, Rise. Thanks, Ward.
Thanks, Ward.
See you soon.
You're welcome. My pleasure.
Take care.
I'm done asking for your permission. I'm tired of hearing what I can and can't do. I'm done keeping things all to myself. I'm ready to speak up. It starts with me, and it starts now. No longer a lone voice, dancing in the crowd. Time to rise up and be counted. Time to stand up and be heard. I'm gonna make you see me. I'm gonna make you hear me. It's time to rise. No more hiding in the shadow. It's time to level the playing field. I'm a warrior, I've got nerves of steel. I'm done walking through your minefield. It starts with me, and it starts now. Oh, no longer a lone voice, standing in the crowd. Time to rise up and be counted. Time to stand up and be heard. I'm gonna make you see me. I'm gonna make you hear me. It's time to rise. Everybody come together. Time to stand as one, hand in hand. Together we stand. Oh, we've only just begun. It starts with us, and it starts now.